So in Hong Kong, we have progressed beyond the UK, and this is one of the few areas where the common law of Hong Kong has really taken off, although it's not, aren't a lot of decisions, but uh, gradually eased into a type of law that reflects its own economic and social circumstances, even if those economic and social circumstances do not reflect what has traditionally been found in the UK. And with common law, that's a problem. If you tie your common law to a foreign country with a different social structure and a different economic structure, then common law, which is supposed to reflect what the community sees as just and fitting, can end up to not fit so well, simply because if it's not fitting in the UK, it might not be found to be fitting in Hong Kong, even though people in Hong Kong are seeing a different kind of social and economic circumstance, right? So what we have in the Luck Continent decision is exactly an analysis of something that we do not find in the UK. Okay, so in Luck Continent, we have a listed company, CY Foundation, and it has a substantial shareholder, Luck Continent. Luck Continent originally was an extremely dominant shareholder before the company was listed. So Luck Continent had in excess of 90% of the voting rights. When the company was listed, they brought themselves down to in the 40s for voting rights. This is not common in the UK to have a listed company with very large blocks of shares held. Now, the CEO of Luck Continent did not get along well with a Madame Yong, who had some allies. And Madame Yong and her allies constituted about 25.2% of the vote at the time that this action was filed. The problem was that CY Foundation was not complying with the Hong Kong listing rules. It was complying with the law of its home company, country of incorporation, whereby a director could be removed only with a special resolution. Hong Kong would see that as weak investor protection, and so Hong Kong requires in the listing rules that a director may be removed as under Hong Kong Company Ordinance with a simple resolution, an ordinary resolution, a simple majority, and that makes it easier for the members to protect themselves against a director whom they do not like. Now, Luck Continent heeded the warning that came from the Stock Exchange of Hong Kong that CY Foundation had better amend its articles to come in compliance with listing rules, or CY Foundation would be taken off the stock exchange. If a company is taken off the stock exchange, the value of its shares plummet. The effect will be instant. It would be almost impossible that when a company is delisted from the stock exchange, its shares continue to have the same value. So Luck Continent is 100% in the right by seeking to amend the Articles of Association to comply with the listing rules. That is, in creating a majority rule article whereby a director can be removed by simple majority, no longer special resolution. Madame Yong, because of some personal relationship with the CEO of Luck Continent, brought her allies into swing and stopped this from happening, which meant that CY Foundation became suspended from listing on the Stock Exchange of Hong Kong. The value of the shares plummeted. Luck Continent sued, arguing that this was conduct of the affairs of CY Foundation in a manner which is unfairly prejudicial to the members. Madame Young and her attorney responded that this is a listed company. This is not a quasi-partnership. This is not a company in which their personal relationships are established. Continent argued that actually all of the members understood that the company should comply with the listing rules. And that compliance itself is the understanding. That is that the company should act in such a way that it comply. Madame Young also argued that voting one's shares is a personal prerogative, and this had nothing to do with the company. This was how Madame Young chose to vote her shares, and her allies took the same position. Continent responded that no, actually, the action of the company we're talking about is the amendment of the Articles of Association. The amendment of the Articles of Association cannot take place without the voting of the shares, and this is how it went to court. The Court of First Instance, which I'm asking you, probably I think it would be the better to read. You can also read the Court of Appeals, or actually choose which one you want to read. The facts are a little bit more extensive in the Court of First Instance. In the Court of Appeals, there are some slightly clearer statements of the law. In any case, the judgment at the Court of First Instance is affirmed with no change by the Court of Appeals. And the case also is taken to the Court of Final Appeals, where it is affirmed once again. You can see why this would be taken to the Court of Final Appeals, because the possibility of bringing an unfair prejudice action into a listed company is a substantial increase in the protection of members. And there very well may be some members in the company, or a class of persons who invest in companies, who do not want to see themselves sued by other members because of the manner in which they use their voting rights to govern the company. And so this is a decision which takes the unfair prejudice action ahead of where you will find it in say the UK. So this is an area where Hong Kong really has created a rule which it needs, because Hong Kong has listed companies with dominant members and the UK does not. So this was very brave of, I think, of the Hong Kong courts, crafting law which corresponds to their actual needs, especially given the problems of public opinion which surround any movement away from the existing UK law in Hong Kong. And these graphics simply show you the movement that Continent was trying to achieve and the blocking by the Madame Young group. And take a look at these summaries and snippets that I give you from the argument. The final case we'll look at is Hong Kong jurisdiction for an unfair prejudice action against foreign companies. And in this case, we will not focus on the jurisdictional issue, but we will look at the case, you'll understand the case, and then when we conclude this course next week by focusing specifically on how to bring these foreign companies into the Hong Kong courts, then you will have the factual background. Right. So in the Yong-ki decision, which is the Kam Lung Sui Kwan and Kam Kwan Lai decision, which again we have decisions at the Court of First Instance, the Court of Appeals, and the Court of Final Appeals. We're talking about a British Virgin Islands company. So we have Kwan Sr., who establishes the Yong-ki restaurant that you may have eaten at and be familiar with. It's very well known on Wellington Street. And his business goes well, and this is the story of many people of his generation in Hong Kong. As the business becomes larger, he expands and diversifies. At a certain point, he decides to take the business into a holding company structure in the British Virgin Islands. Right? So he sets up Long Yao, which is a BVI company. Long Yao becomes the operational holding company, and Long Yao is owned by Yong-ki Holdings. And this is the structure that he establishes as he then prepares to hand the company over to his two sons, Quan Sing and Quan Lai. The children had received the expectation that they would be taking on the family firm as partners, and the structure which Quan Sr. created was with an eye toward this. On the graphic, I'm giving you companies which are British Virgin Islands in blue, and companies which are Hong Kong in red and white. Right? So we have a relatively large corporate group. The operational companies are in Hong Kong. Yong-ki Restaurant is in Hong Kong. One of, I think, a prize winner for a name of a company. Remember, companies must use the word limited, and so they're stuck with the word limited after their company, which in some ways could be negative. But they also then, in the Yong-ki group, set up a club, which was called Life Is Not. And so with the obligatory addition of limited, the club was called Life Is Not Limited, which is certainly a nice name for a club where you're supposed to enjoy yourself. The group continues, and the group does pretty well. And then as the two brothers age and become more senior, Quan Lai, the younger brother, decides to take on more power in the company. Right? So he becomes quite the alpha figure. Eventually, during the proceedings, Quan Sing, who is the plaintiff here, passes away. I have no idea whether this is caused by the proceedings, but certainly when you read the facts, you see that he can't have been happy about what was happening in his family, because this was affecting his children as well. It's essentially one part of the company disinheriting, or one part of the family disinheriting to a certain extent another part of the family. And so this is the case, and the primary difficulty that we'll look at next week is whether, when we have a holding company whose only job is to hold shares in another company, and that other company is also foreign, will there be considered to exist a place of business for Yong-ki Holdings in Hong Kong? Right? So remember, the unfair prejudice action is something which may be filed by a member of a company established under Hong Kong law, or by a member of a non-Hong Kong company. And a non-Hong Kong company can either be a company which is registered under Part 16 of the company's ordinance, or a company which has a place of business. Here, Yong-ki Holdings was not a Hong Kong company, it was British Virgin Islands. Yong-ki Holdings was not registered under Part 16, but the question is, did Yong-ki Holdings have a place of business in Hong Kong? Now, the separate question, which was discussed even though jurisdiction was not certain, is whether Quan Lai, in his behavior toward Quan Sing, was behaving in a manner unfairly prejudicial to Quan Sing. Now, if we were to apply a test which looks at prejudice and unfairness separately, if we were to be tidy in that sense, let's say we look to see whether, first of all, is there prejudice against Quan Sing? And prejudice, taken alone, could mean essentially, did Quan Sing lose money? And he really didn't lose money, and so there the case could stop. But that's not the way the action is formulated. If you look at the action, it's the affairs of the company have been conducted in a manner unfairly prejudicial, right? Unfairly prejudicial. So these are adverbs that are modifying conduct. And so this is not an action which neatly separates into prejudice on the one hand and unfairness on the other, prejudice being money, and has the loss of money been unfair? Well, we determine that and then we decide. That is a tidy way to approach things, but that's not the way the law is written. And also, that's not, this action is a very strange action. And as you'll see in the facts, what Quan Sing is arguing for is something close to dignity. He wants to be treated as someone who belongs, and that's what he's looking for. And certainly most people would not count dignity as an economic right. Right? So this case is decided at the court of first instance, finding no jurisdiction, and yes, probably unfairly prejudicial conduct by Quan Lei. It goes to the Court of Appeals, and the Court of Appeals finds no jurisdiction and probably no unfairly prejudicial conduct by Quan Lei, again looking to something tangible like control and economic value. Right? It goes to the Court of Final Appeals then, and we find, yes, there is jurisdiction, but not from the place of business test. It actually comes from the test for winding up the company. As I said at the outset of this lecture, winding up a company for just and equitable reasons is very close to an unfair prejudice action, which can result in winding up the company. And then the Court of Final Appeals also finds that the behavior of Quan Lei was, in fact, unfairly prejudicial. So please do read this case both for the jurisdictional issues, which will save you time for next week, and also for the determination of the fact of unfair prejudice. The facts in the Court of First Instance decision are a little bit more thorough, but because we do have a back and forth where the Court of Appeals has rejected the Court of First Instance, and then we really do need to depend on the Court of Final Appeals, I'm giving you this site for the Court of Final Appeals decision. And here again are some snippets. Please do not allow this guidance to prevent you from reading the entire case. This is unfair prejudice. I think you'll enjoy looking at this. It's a unique action, a very flexible action, and a very interesting action. It's also extremely common in Hong Kong, or at least common compared to the derivative action. We have about double the number of unfair prejudice actions than derivative actions. And as I said, it's also quite unique in the sense that the unfair prejudice action has developed the common law beyond what we see in other common law countries. So the common law as taken from the UK has been evolved farther by the Hong Kong courts, which is in itself an interesting development. I look forward to seeing you when we discuss our application of law problem.